sexual harassment and discrimination in the workplace. It's explosive, expensive, and extensive to the highest levels of management. Yet, despite all the widespread publicity about successful sexual harassment suits, many businesses appear unsure of what to do about it. As a result, sexual harassment remains a clear and present danger to businesses. They must act now or face increasing risk of liability. Considering that failure to adopt a proactive and aggressive approach on this issue often results in costly lawsuits, loss of employee morale, decline in productivity, and erosion of public image, doesn't it make sense for companies to take protective measures to prevent these complaints? Yet, most do not, until it's too late. Employers now have legal tools that may protect them from being successfully sued for sexual harassment and discrimination. The United States Supreme Court emphasized that employers may be found liable based on how they handle complaints of sexual harassment. Employers may be able to escape liability or reduce damages in a sexual harassment claim if they take reasonable care to prevent, halt, and remedy any harassment. Reasonable care includes adopting an appropriate sexual harassment policy and dissemination and implementation of that policy. Simply having a harassment policy and complaint procedure is not enough. Employees must know about these policies and procedures, and employees, supervisors, and managers must be trained in them. The Supreme Court also made it clear that employers must investigate a complaint in order to show they took prompt corrective action. Is your company protected? Have you established policies educating your employees about sexual harassment and what to do about it if it happens? Do your employees understand exactly what constitutes sexual harassment? Do you have an unbiased outside investigator? An internal investigation may not be enough. And if you are sued, do you have counsel experienced in sexual harassment litigation? If you cannot answer yes to these questions, contacting the law offices of Ted Justice Williams could be the most important step you take. Ted Williams is a nationally renowned criminal and civil trial attorney who has represented victims of discrimination throughout the United States. Williams took the landmark harassment case, Curry versus the District of Columbia, all the way to the Supreme Court. Experienced in all phases of harassment, he knows what's at stake. Moreover, Ted Williams has lectured extensively on criminal procedures, harassment and discrimination, and sensitivity training for companies, universities, and colleges nationwide. He knows training. Ted Williams is also an experienced investigator, having served 18 years as a criminal investigator and police officer with a major metropolitan police department, and as a special agent in the federal government. He knows investigation. But then you may already recognize Ted Williams because he is also a television personality. Ted Williams appeared as a regular on the nationally televised show Power of Attorney and as an on-camera legal analyst for national television programs such as On the Record with Greta Van Susteren, Hannity and Combs, Bill O'Reilly, Crossfire, Court TV, Fox News, CNN, and more. He knows how to capture and hold an audience of one or millions.
Hello, I'm Ted Justice Williams, and I urge you not to wait until it's too late or too expensive. Confront and address sexual harassment now. My law offices are there for you. We offer you, the employer, the complete package: implementation and review of your anti-harassment policies, training and education of your supervisors and employees regarding sexual harassment. We also have the ability to investigate claims of sexual harassment as well as litigate those claims. Let us help you. A call to my law firm will save you thousands, if not millions of dollars. We're here to serve and protect you. Contact us today.